Rick, please over to you.
Okay, thank you, Fleur. Thank you, everyone. My presentation I've called Raising Capital, AFSL and Managed Investment Scheme Roadmap, and I'll be discussing the regulatory framework under the Australian Corporations Act of raising capital through managed investment schemes and the Australian Financial Service Licence requirements. Although this law is not new, it is a complicated area and there's a lot of confusion that still reigns. I understand that my audience are predominantly lawyers from Australia and New Zealand, and some of you may know this area quite well, but I'm assuming limited knowledge and will hopefully by the end of the session have removed any confusion you might have. As a sobering start to get your attention and as a stark reminder of the risks of non-compliance, I briefly want to mention the recent jail sentence of a Melbourne accountant, Mark Letton, to 5 years jail for his role in promoting property projects as unregistered managed investment schemes without an AFSL licence. So I'll move along to the next slide that hopefully you can see, which is an overview of my presentation. And as I said, the AFSL acronym stands for an Australian Financial Service Licence, which is issued under our Corporations Act, and it's regulated by ASIC as our corporate regulator. The AFSL regime is not a one-size-fits-all. There are different types of licences. It can apply differently to companies and trusts, and whether you are the issuer of a financial product or an advisor to an investor. And what I'm focusing on is the AFSL regime as it applies to a typical property syndicate or property trust. And the reason is because these are commonly used, and in my experience they're commonly misunderstood. But some of the law that I will discuss also applies equally to companies, and I'll touch upon that through my presentation. I'll take you through when you need to have an AFSL, and also when you have a managed investment scheme that requires registration. I'll talk about the small-scale offering exemptions and the different types of investors for both the different types of investors that can invest into these schemes, including self-managed super funds. And I'll talk about the accountant certificate that is commonly used as a means to qualify a wholesale client, and I'll talk about that. And hopefully we can cover this in the hour. You'll see I've put a caveat or an apology that it is a regulated corporations topic, so apologies for some of the detail. I've put up on the screen a couple of statements that I think are commonly misunderstood. I hear them often. The first, that the property trust doesn't need to be registered because it has less than 20 investors, or another one being that the trustee doesn't need an AFSL because the investors are all sophisticated or wholesale. And these statements are wrong and they're dangerous, and it will hopefully become apparent through the presentation why that is so. So I'm going to run the presentation adopting a hypothetical case study that you can hopefully see on screen. But first, a disclaimer that any resemblance of any person in my case study to any living lawyer is purely coincidental. But in my case study, I've got three lawyers, P, A and L, and I must confess that they do look strikingly similar to some of my partners. But L is a property lawyer, and L knows a bit about property and finds this development site that he thinks is a great investment opportunity that you can hopefully see in the screen there, in the middle of the screen. And so he has his partners in his law practice, and I've called them P and A, and L talks P and A into doing the development of this great investment opportunity, and so they call themselves Power Property, and just to distinguish themselves, I give them a trademark which you can hopefully see in the screen. So let's go to their first project, which they call Property Trust Number 1. And this is structured as a standard vanilla unit trust that many of you will be familiar with. It has a trustee company, Property Pty Ltd. The directors of that company are Peter, Angelo and Lawrence, and they are also the shareholders of that trustee company. And being a unit trust, it has unit holders, and the unit holders are the respective three family trusts for each of Peter, Angelo and Lawrence, and they each invest $50,000 into this unit trust. So my question is whether the number 1 trust is a managed investment scheme. So to find the answer, we have to open the book, or as I sometimes call the Bible, and I'm referring of course to the Corporations Act, and you start at section 9 with the definition of a managed investment scheme, and there are essentially 3 elements of a managed investment scheme. The first is that people contribute money to acquire rights, being the interest to the benefits produced by the scheme. Second element is that their contributions are pooled to produce financial benefits for those members who hold those interests. And the third and important element is that the members do not have day-to-day control over the operation of the scheme, whether or not they have the right to be consulted or to give directions. So, looking at Property Trust Number 1, is that a managed investment scheme? Well, I think the answer is no, because every investor, being the unit holder, has some day-to-day control of the trust, because each is separately represented by its own nominee director of the trustee company. Peter, Angelo and Lawrence are the directors, and the only investors are their respective trusts. So if it's not a managed investment scheme, you can put the Corporations Act away and go ahead and do your property development project through that trust. But let's say that Power Property makes a bit of money on the number 1 project and they decide to do it again, and this time they want me in on their investment. And I say okay, I will, but it's purely hypothetical because I never have any money to invest. But I don't want to be a director of their trustee company because of the director risks, etc. So they form trust number 2, and I invest my hypothetical $50,000. It's essentially the same structure as trust number 1, but in this case I'm an investor but not a director. So my question is whether trust number 2 is a managed investment scheme. So firstly, is number 2 trust a managed investment scheme? I think the answer is yes, it is, because I do not have day-to-day control of the operation of the trust. I am essentially a passive investor, and because I don't have day-to-day control, then going back to that definition, the third element in section 9, it meets the definition of a managed investment scheme. So on that basis, the next question is whether or not the units in the number 2 trust are a financial product. If they're not a financial product, then once again you can close the Corps Act and go ahead and do your project. But if it is a financial product, then we have to keep going. So in determining whether or not the units in the number 2 trust is a financial product on the basis that the number 2 trust is a managed investment scheme, they will be a financial product if either the trust has more than 20 unit holders or investors, or the trust was promoted by a person, say the trustee, who was in the business of promoting schemes. the converse is that the trust will not be a financial product if the trust has 20 or less members or unit holders, and the trust was not promoted by a person in the business of promoting schemes. And you'll find references to the relevant sections of the Corps Act that deal with this issue. So in my example, clearly trust number 2 has less than 20 unit holders. So the question is, did Power Property promote number 2 trust to me, and was Power Property in the business of promoting schemes? So what is the meaning of promoted and being in the business of promoting? There's no clear-cut black and white answer. Promoted is not defined in the Corporations Act, and courts have interpreted the term broadly. You can be in the business of promotion. I'll refer to a case of ASIC and Young, a 2003 case, where the courts held that promoted extends to activities in which a person formulates a scheme, advertises it, solicits others to participate, and embarks on its implementation. But there's also been commentary that there's no reason why promotion of a single and first scheme could not constitute being in the business if the methods of promotion are characteristic of a business rather than informal approaches to friends and acquaintances. And for that commentary, you can refer to ASIC and, against IP Product Management Group, a 2002 decision. So the number 2 trust is possibly okay on the grounds that it was not promoted by Power Property because it was only offered to me as an informal acquaintance of the directors, myself being a partner in their law practice, and Power Property directors' main business are lawyers. But I recommend taking a conservative view on this issue because I do get clients who say, well, we're putting a project together and we've only got our business acquaintances involved, so we're not really promoting it to them. And I tell them to exercise caution because if they do the first project and they make money for their investors will pat them on the back and say, great, where's the next one? But if they do a project where it goes pear-shaped and they lose their investors' money, then the first thing the investors are likely to do is go and consult their own lawyers who will look at this issue and go and complain to ASIC, and ASIC may well come down on the client on the basis that they were promoting. So, as I've said in my slide, take a conservative view. So, moving on to the next example in our case study is property trust number 3. And in this example, Power Property sends a 2-page offer memorandum widely to the Madgwicks accountants database, inviting them and their clients to invest into the number 3 trust. So the question is whether or not the number 3 trust is a financial product. I think the answer is clearly yes, because Power is in the business of promoting the scheme. And on that basis, that leads to the next question of whether or not Power Property needs a licence in order to conduct the number 3 trust. So, to determine whether you need a licence, you look to Section 911 A of the Corporations Act, which provides that a person carrying on a financial services business in Australia needs a licence. And a person is taken to provide a financial service if they deal in a financial product or provide financial product advice. This is not exhaustive, these are just some examples. And dealing is taken to include issuing the financial product. So when Power Property offers to issue or issues the units in the number 3 trust, POW is dealing in a financial product and therefore carrying on a financial services business. And POW therefore needs a license. So at this point, when I tell Peter, Angelo and Lawrence that they need a license, they get a bit upset with me, which is not uncommon. So they ask me if they do the number 3 project through a company structure rather than a trust structure, and they issue shares, will that overcome the need for a license? Well, it's slightly different, but let's consider the position. So a financial product includes, amongst other things, managed investment scheme interests, which, as we've said, units in a trust, but it also includes securities, which include shares in a company. So do you avoid the need for a license if you use a company and issue shares? In most cases, in this context, the answer will be no. It's commonly thought that a company can issue its own shares to shareholders without a license because that doesn't constitute a dealing, and that is certainly the general rule, but it's not necessarily so because there's exceptions which apply where if the company carries on a business of investing in shares, land or other investments, and the company invests the funds that are subscribed after making an offer to the public, then the company's issuing of shares is a dealing. And an offer to the public, which is defined in Section 82, is broadly defined. It includes an offer to any section of the public, whether or not selected as clients of the person making the offer, and notwithstanding that it can only be accepted by the person to whom the offer is made. So a selective offer to a small group of clients or acquaintances can constitute making an offer to the public, and if the objective is to raise capital from them with the view to the company then using that equity to conduct a business of some form of, say, property land development, that will then involve the issuing of the shares being a dealing for which they need a license. So is there a solution? Well, one solution that can be used is an exemption where a client doesn't want to get their own license either because of the cost or lack of experience, and that's called the intermediary authorisation. The law allows a product provider, in our example, Power Property as the trustee, to be exempt from a license if the product provider issues the product, which are the units in the Power Trust, under an arrangement which is defined as the intermediary authorisation between the product provider and the AFSL licensee. And then the licensee offers to people to arrange for the issue of the product by the product provider, and then the product provider issues the product in accordance with the offer if that offer is accepted. And that's covered in Section 911A2B of the Corp Act. And this can be a useful solution for new entrants to the funds management industry, but they always need to weigh up the pros and cons of getting their own license as opposed to hiring an existing AFSL licensee as an intermediary and relying on this exemption. So I'm moving now to Power Property Trust number 4. Now POW's doing really well, and Madswicks gets POW an AFSL license without too much difficulty, and POW then prepares a 35-page information memorandum seeking to raise $5 million in equity
It advertises in the AFR. The unit trust deed allows power to charge a management fee. And so my question is, does the number 4 trust need to be registered with ASIC? Now the answer here, yes, no, maybe, not sure. I'm not sure if there's a system in this webinar Ready Talk for doing a poll, but as I'm a novice to this webinar concept, I'm going to take a punt that most of you are saying maybe. Well, in which case, you would all be absolutely correct, because it does depend. So the question on whether the trust needs to be registered with ASIC, the general rule is that the managed investment scheme must be registered if it has more than 20 members or it was promoted by a person who was in the business of promoting schemes. And as I said earlier, there is a risk that one scheme can be a business of promoting, and that's covered in section 601ED. But as many of you will be aware, in the Corps Act, every general rule seems to have an exemption, and in this case, there is one which covers when a MIS trust does not need to be registered, and how that applies is that the trust does not need to be registered if none of the investors would require to be given a product disclosure statement. And a product disclosure statement, or PDS as it's commonly referred, is the Corporations Act regulated offer document that is used for managed investment scheme trusts. It's similar to a prospectus used for companies, and therefore a managed investment scheme must be registered if any one investor is required to be given a PDS. So when does a PDS need to be given? Well, the general rule is that the product provider must give a PDS when it offers to issue the financial product or issues the financial product to a person as a retail client. But once again, there are exemptions. And a PDS is not required to be given when, in really two main situations that I want to cover. The first is the small scale offering in section 1012E, and the second is where the investor is a wholesale client. So firstly, the small scale offering. This is also referred to as the 2 million 12-month 20 investor rule. And the issue, it works as follows. The issue of a financial product by a product provider does not need a PDS if the product provider only raises up to $2 million from personal offers that are accepted by no more than 20 investors in any 12-month rolling period. So it's very important to remember that it must be a personal offer. It's not just a case of $2 million, 20 investors, 12 months. It must be a personal offer. And this is an offer that is made to a person who is likely to be interested in the offer, having regard to previous conduct, some professional or other connection with the product provider, or statements or actions that indicate that they're interested in such offers, and it may only be accepted by the person to whom the offer is made. So, for example, it would not be a personal offer if the investor has only responded to public advertising of an offer, or if the investor was put on your mailing list, but you've had no prior personal contact with the person to qualify their interest. You need some form of positive indication of interest by the investor in receiving the future offer to invest before the investor receives the offer. So what then is a wholesale client? This is another category of investor where you don't need to give a PDS. And you will typically see offer documents or advertisements saying restricted to wholesale clients only. And what this is intended to mean is that the scheme does not need to be registered because it's restricted. It may in fact be registered, but as I'll explain, it doesn't need to be. So the main wholesale client situations are as follows. Where the investor invests $500,000 or more for the product, and that's what I loosely call the default position, because then you're automatically treated as wholesale. The second category that's commonly used is where the investor provides an accountant certificate certifying that the investor has $2.5 million in net assets or $250,000 of gross income in each of the last 2 financial years. Another category of wholesale client is what's referred to as the professional investor, which includes AFSL licensees, stockbrokers, financial planners, etc. And the term wholesale client is similar to sophisticated investor that appears in relation to companies in Section 708. It is confusing that the Corporations Act makes distinctions between companies in sophisticated investors in 708 and wholesale clients in 761. But they're similar concepts, and they're both covered by the accountant certificate, which is what I want to turn to now. The accountant certificate is a certificate that is given by a accountant that gives the certification I referred to about the income or gross assets. It's valid for 2 years from its issue date, and it should be issued to and name the individual person, who I call the certified person, who controls the relevant family group of companies. The reason for that is you can then aggregate the income and assets of the certified person and his or her controlled entities, including companies, trusts and self-managed super funds. And it will not matter in that way whether the certified person is in fact the proposed applicant or whether the certified person individually meets the net asset or gross annual income criteria. So for example, if my family group includes myself and my family investment trust and say a self-managed super fund, and collectively aggregated we meet the 2.5 million or the 250,000 income thresholds, then I can be the certified person named in the certificate even if I don't personally meet the threshold. And also I don't have to be the applicant investor. I can form a new entity with no prior income or assets specifically to be the wholesale client investor, as long as I control that entity. So, in terms of meaning of control, this is covered by Section 50 AAA of the Corps Act, and you'll have Entity A being the certified person controlling Entity B if Entity A has the capacity to determine the outcome of decisions about Entity B's financial and operating policies. And you can take into account practical influence that Entity A can exert and any practice or pattern of behaviour. So that is how you can bring into the family group a number of different entities that can be controlled by the individual who is certified by the accountant. And I think it's an important area to know and to be explained to accountants when they're asking you about how do they complete these certificates. I'm turning now to the issue of whether or not self-managed super funds need $10 million to be wholesale client investors. The reason I want to briefly mention this is because there has been in recent times discussion on this issue, because ASIC had some years ago issued a question and answer statement where they indicated that all self-managed super funds had to be treated as retail clients unless they had $10 million. And what that meant was that it was for fund managers who were offering wholesale fund products, they weren't able to include a number of self-managed super funds as investors that didn't have $10 million in them. Well, I never thought that ASIC had that view correctly stated previously, and they've now more recently clarified the issue and withdrawn the previous Q&A, and they basically said that you can treat the self-managed super fund on the ordinary wholesale client test. But my view is perhaps not quite as broad as what ASIC has indicated, but I think if you have a careful look at the relevant legislation in 761G6B, I think the position is that there are potentially two separate financial services that can be provided to the self-managed super fund investor. One is by the product manager, who is the product issuer, who deals in the financial product by issuing it to the investor, and the fund manager can treat the self-managed super fund as a wholesale client applying the ordinary wholesale client test. The fund manager, of course, does not provide personal financial product advice to the investor about whether or not to invest. So if that self-managed super fund chooses to go and see their financial planner to obtain personal financial product advice about whether or not to invest into the fund, in that situation, if the self-managed super fund doesn't have $10 million, the financial planner must treat the self-managed super fund as a retail client and give the self-managed super fund a statement of advice and all the other compliance obligations that go with giving personal financial product advice, which I'm not going to go into detail in this presentation. But to sum up this issue, a fund manager offering a wholesale fund can accept self-managed super funds into that fund by applying the ordinary wholesale client test, regardless of whether the self-managed super fund has $10 million or not. So in summary, with your unregistered wholesale managed investment scheme trust, your investors can be up to 20 personal offers under your small scale offering investors and any number of wholesale client investors. And because none of those investors are required to be given a product disclosure statement, that trust does not need to be registered as a registered managed investment scheme. So now Pal Property is continuing to advance, and it does its number 5 trust, and this time it's a fully fledged fund manager, and it wants to do a retail fund including retail investors. So what is required in this situation? Well, obviously it needs, in terms of a disclosure document, a regulated product disclosure statement complying with the Corporations Act, but importantly it also needs the trustee to have a responsible entity authorisation under its AFSL to operate a registered scheme. And that, as I said earlier, the AFSL is not one size fits all, and this is a specific authorisation to operate a registered scheme under 766A(1)(d), and with that authorisation the trustee is referred to as a responsible entity under our Corporations Act, and having obtained an AFSL that authorises it to operate number 5 trust as a registered scheme, Power Property can then make an application to ASIC to register the number 5 trust as a registered scheme under section 601 (EA). In conclusion, I've gone fairly quickly through the legislation, but hopefully that's given you a better understanding of the area. It is complicated. The restricted wholesale client capital raising is a well-trodden path for raising capital. It involves less red tape than registered schemes, and also obviously less cost in running a wholesale fund than a registered retail fund. But the risks and penalties are significant if you get it wrong. I mentioned at the beginning Mark Letton's case, where he got 5 years jail for operating an unregistered managed investment scheme without an AFSL. And I might just close by referring briefly to a paragraph from the decision in the reasons for sentencing that was delivered by His Honour Judge McInerney, where His Honour said, as best as I am able to analyse the schemes, they demonstrate in totality what can be described as an economic schmozzle, which was doomed to failure. This whole enterprise, which was overseen by Mr. Letton, had more severe structural defects than the Titanic. Like the Titanic, it sank ignominiously. And I think it's good to see that His Honour Judge McInerney has an understanding of the language used by my tribal ancestors. And for those that don't know, schmozzle is a Yiddish word meaning mess or confusion. And that's what Mark Letton got himself into without being licensed, and he's now paying the price. ASIC Chairman Greg Medcraft said in his media release about Mark Letton's sentencing, he said, Mr. Letton acted in complete disregard for the law and with little concern for the interests of the investors. His jailing should send a strong message to company directors and scheme operators about the serious consequences of operating property investment schemes outside the legal requirements. So on that note, I might finish the formal part of my presentation, and happy to take any questions if there are any.
Okay, Rick, we've got a few questions here already, but if anybody else has any questions, please feel free to type them in now, and then we'll read them out and Rick will answer them. So just the first question we've got, if a foreign fund manager is licensed in its own jurisdiction, does it need an Australian Financial Services licence to operate in Australia?
Thanks for that question. The answer is there are some exemptions and relief that ASIC have granted that can be used, but it's not a blanket exemption. So you really need to look at the jurisdiction of the foreign fund manager and their licence, and then work out how that weeds into our provisions and the exemptions that ASIC has granted to determine whether or not they will be exempt from needing a licence in Australia.
Okay. The next question is, if a fund manager is operating multiple separate project trusts, does the small-scale offering apply to the aggregate of them or to each trust individually?
Yeah, that's a good question. The answer is that each trust stands as its own separate financial product. So that means that in counting the 2 million 20 investor 12-month rule, you look at each trust as a separate financial product and you don't aggregate across multiple trusts.
Okay.
And so that's an important thing to know for fund managers that are operating and looking to take advantage of the small-scale offering.
Okay. The next question is Section 761G sub 7 of the Corporations Act says the accountant certificate is only valid for 6 months. So I think you might have said it's valid for 2 years. So we're just wondering which of the two it is.
All right. Well, thank you for that. And I must say that is a good. I'll confess to that being a nice Dorothy Dix question because I wanted that to be asked because it's apart from answering the question, I think it gives me an opportunity to provide a bit of mentoring for the younger lawyers that are listening to the presentation because it's a trap that the Corporations Act looks, so often it provides traps for us in the way it's set out. In this situation, yes, when you go to the main section in the Act, it says the accountant certificate is valid for 6 months, but you then need to look at the regulations, and buried deep in the middle of the regulations is 7.6.02 capital A, capital F, which substitutes 6 months for 2 years. So I always tell our younger lawyers here, don't just rely on what you read in the Act. You've always got to check your regulations and your ASIC class orders and release to check that there are no modifications to what appears in the Act. And this is an example of that.
Yeah, that's a pretty big trap. So we've just got one more question, but then after that I haven't seen any more questions come through. So if you do have a question, then now's your time to type it in. But Rick, under the new limited license requirement for accountants, which starts mid-next year, will accountants need a limited license in order to provide an accountant certificate certifying a wholesale client?
That's a good question. No. The limited license regime is intended to apply to accountants giving advice about setting up of self-managed super funds, and ASIC has put out recent media releases that these accountants will need to get their skates on, because if they don't apply or have their license arrangements in order by about March of next year, then they're going to struggle to have their license in place in time for the 1 July starting date of that new limited license regime for accountants. But in the context of the accountant certificate, no, the accountant will not need a limited license in order to provide the accountant certificate.
Okay. All right, well, that's the end of all the questions that we have, so I might hand over to Fleur.
Thank you very much, Roxy, and thank you very much, Rick, for the presentation. As I mentioned at the beginning of the webinar, the presentation slides and the link to the webinar will be circulated at the end of this presentation, and you can find a link to the webinar on our website, Meritus website, www.meritus.org. meeting request and reminder, hopefully not as many as last time, but will be circulated to you closer to the date of our next presentation, which will be in October, and will be the 1st of October, and hope to see you all then soon. Thank you very much.
Thank you, Fleur. Thank you, everyone.
Thank you.